Most DUI cases never actually make it to trial. And today I'm breaking down the 4 secrets that could save you thousands of dollars and months of stress in your DUI case. I'm Dan Joffe, DUI lawyer at NextLaw. I've noticed there's a lot of misconceptions about how DUI cases really get resolved. Today I'm going to pull back the curtain to show you what exactly happens behind the scenes. Part 1, the power of resolution meetings. Let me tell you something most people don't realize. There's this thing called a resolution meeting, or what we lawyers call a Crown pretrial. Think about it. Before any major deal in life, what happens? People sit down and negotiate. That's exactly what happens in these meetings. But here's what makes these meetings so powerful. They happen completely behind closed doors. It's just me and the Crown lawyer having an honest discussion about your case. No judge, no jury, no public gallery watching. And you know what? Most of the time, this is where cases are won or lost. Part 2, the strategic timing factor. Now let's talk about something that could make or break your case, timing. Most people think these negotiations happen right before trial, and that's wrong. The truth is, timing is everything in DUI cases. The best DUI defense lawyers know exactly when to initiate these discussions. It's like playing poker. You need to know when to show your cards and when to hold them. And here's how it really works. First, we get all the evidence, police notes, breathalyzer results, witness statements, everything. Then we analyze it thoroughly. Only then do we meet with the Crown. Why? Because you never want to negotiate without knowing exactly what cards you're holding. Part 3, the art of negotiation. This brings us to the real secret sauce, the art of negotiation. There are 4 main strategies that experienced DUI lawyers use during these meetings. First, we present your personal circumstances in the best possible light. Maybe you've never had a criminal record. Maybe you've already completed some counseling. Maybe your job depends on your ability to drive. These factors matter more than most people realize. Second, we identify technical defenses. Did you know that even a few minutes delay in the breathalyzer test can make the difference between the results being admitted and inadmissible? Or that certain police paperwork errors can get your case thrown out. Third, we focus on the Crown's weaknesses. Every case has them. Maybe a witness statement doesn't match the police report. Maybe proper procedure wasn't followed. Maybe there are other charter violations. Fourth, and this is crucial, we know what a reasonable deal looks like. When you've handled a lot of DUI cases, you know exactly what's possible and what's not. Part 4, the alternative solutions. Now here's where it gets really interesting. Most people think DUI cases have only 2 outcomes, guilty or not guilty. It's not true at all. Let me introduce something to you called a careless driving plea. It's like a secret third option that most people don't know about. Instead of pleading guilty to a DUI, sometimes we can negotiate a plea to a careless driving charge under the Highway Traffic Act of Ontario. What's the difference? Well, one's a criminal offense, the other isn't. One gives you a criminal record, the other doesn't. But here's the catch. You just can't walk in and demand this deal. It takes careful negotiation, proper timing, and most importantly, knowing how to present your case in a way that makes the Crown willing to consider this option. The bottom line. Look, I'm not saying every DUI case can be resolved without trial. Some cases need to be fought in court. But what I am saying is this: if you understand how these resolution meetings work, if you know the strategies I've just shared with you, you're in a much better position to get the best possible outcome. If you're dealing with DUI charges, schedule a free confidential call with me. The link to book the call is in the description of this video. Thanks for watching.